about the transboundary conception of law to reconstitute our disaggregated world. So I thought that it would be good to start with something more theoretical. And so, Jonathan, without any further delay, I leave the floor to you.
Well, thank you very much, Vittorio. It's a great honor for me to launch our research forum, and I very much look forward to your presentations today. I think Vittorio suggested we begin first by the most boring topic, mine, so that everyone is still awake. So, writing on the theories of recognition, Sir Ian Brownlee observed that theory had become like a bank of fog on a still day. He later sharpened that stance in his Hague Academy course, remarking that theories of law are one of the principal causes of low morale amongst students of international law. Yet I take the risk of speaking today not only about legal theory, but about a legal theory that's not even about international law. I can therefore only hope that your morale proves more resilient than Sir Ian feared. So in my presentation today, I'll put forward a very modest and entirely uncontroversial claim that if we, as legal scholars, want to or work to matters for policy, we should all adopt the transboundary conception of law I propose. By this conception, I mean an approach to developing normative frameworks that move across conventional boundaries in order to reconnect the fragments of our world pulled apart. I suggest that it is through such an approach that scholarship can meaningfully contribute to the greatest challenge of our time, including the climate crisis, the disruption caused by artificial intelligence, and the return of economic warfare. So rest assured, I must immediately add 3 caveats to my overbroad claim. First, developing this project will probably be my life's work in one essay, or more likely in multiple essays. So I will limit myself today to make 2 points, which correspond to the 2 parts of my presentation. Second, I very much hope you disagree with me and with those 2 points so that I can send you the essay and benefit from your comments in revising it. Third, through this essay, I seek to contribute to legal theory, as mentioned, much like the substantial scholarship on the methodology of comparative law. I therefore not offer a rigid formula, but analytical principles to guide scholars working across the field. And I should add, these are not draft principles, as I would not presume to compete with the work of the International Law Commission. So the 2 arguments I submit to you today are the following. First, the best conception of transnational law in the literature is as an approach to understanding and developing the law on cross-border legal problems, and this is the important point, which integrates both an internal and external perspective on law. Second, if contemporary legal scholarship is to remain policy relevant, it should begin with the underlying socio-legal challenge that law is seeking to address. Moving on to the first part of my presentation. What is transnational law, and how should it best be conceived? As some of you may know, Philip Jessup popularized the term in the 1950s. He wrote, "I shall use, instead of international law, the term transnational law to include all law which regulates actions or events that transcend national frontiers, both public and private international law included, as are other rules who do not wholly fit into such standard categories." One could say that Jessup's definition is elegant, meaning that it has generated 70 years of disagreement. Since then, scholars have defined or described transnational law as either a problem field, a methodological approach, or an emerging body of rules. Other scholars have approached it as an object of either sociological or critical analysis. I argue that these accounts are not contradictory, but reflect different perspectives on law. The former, internal, and the latter, external, and each concerned with the different stages of development of transnational legal norms. More recently, Harold Coe has suggested that legal scholarship in international law had become increasingly and I quote, policy irrelevant. And conversely, drawing on Marty Koskianiemi's work, I might add that international lawyers dislike legal theory almost as much as they dislike admitting that they implicitly rely on one in their practical work. And if I misrepresent Marty's position, I think our colleague has jurisdiction to correct me. So my contention is that these two seemingly opposite lines of criticism point to the same difficulty. Much legal scholarship loses policy relevance when it's insufficiently grounded in what legal actors do and think. At the same time, it remains normatively underdeveloped when it fails to make explicit the legal theories on which it relies. However, I suggest that the strength of Jessup's approach lies precisely in bringing together the internal and external perspective of own law. And in doing so, he laid the groundwork for both a conception of law and an academic discipline focused on what is shared across legal orders in an age of increasing interconnection and interdependence among states. So I would give you examples from Jessup's lectures to support the point, but in the interest of time, I'll leave them for the essay. So much for transnational law. I now move from the respectable uncertainty of an established concept to the less respectable uncertainty of my own. This is the second part of my presentation. What is my transboundary conception of law, and why is it useful, and perhaps even better than competing approaches? I will later introduce the technical vocabulary I use to describe the components of my transboundary approach of law. But in this brief presentation, I thought it would be more effective to begin by illustrating the conception through a narrow example, which I draw from my own PhD thesis. Whether a state that appears in state immunity litigation thereby waives any objection to alleged defects in service of process. So in other words, whether a foreign state that takes part in state immunity proceedings gives up the right to object that it was not properly served and brought with the documents to bring it before the courts. I appreciate that talking about procedure is not usually how one wins an academic audience, but if theory can survive the test of procedure, it can probably survive most things. So in this example, the different accounts of transnational law I've mentioned earlier would likely begin from different starting points. First, the problem field, which I've mentioned, might ask whether the issue is truly transnational because it concerns cross-border adjudication. The methodological account might ask how we should combine domestic procedure, international law, and foreign law to answer this question. Third, the emerging body of rules might ask whether rules are emerging on waiver by appearance on a foreign state. The sociological account might ask how state, courts, ministries, private parties behave when service is defective, but the state nevertheless appears. Fifth and finally, the critical account might ask whose interests are served by strict service rules or by waivers. So my transboundary conception of law, in contrast, does not begin with legal doctrine, which are often good servants, but just as often bad masters, nor with world problems themselves. It combines the internal and external perspective of law by taking the underlying socio-legal challenge as the organizing principle of the inquiry. It then asks which legal and non-legal source should be brought together to produce a coherent normative framework. In other words, my conception does not reject the 5 accounts I mentioned, but seeks to sequence and integrate them systematically. So, in my example on state immunity, the starting point would be what socio-legal challenge are we trying to solve when determining whether appearance cures defective service in litigation against foreign states? Or to put the question differently, what service of process actually does, how states and courts behave in practice, what legal systems adopt different solutions, what values are at stake, and which legal rules best reconciles the interests of foreign states, private litigant, and forum states. So it's in that sense that my conception is transdoctrinal, transcommunal, transprocessual, transdisciplinary, and transformative. So compared to other approaches, it has a distinctive advantage. It resists premature analytical closure by integrating description, evaluation, and prescription within a single and inductive holistic methodological framework. This is the scholarly vocabulary of my transboundary conception of law, which I've illustrated through the state immunity example. So in conclusion, I hope that you disagree with me enough to read the essay and explain at length what I'm wrong and help clear the fog produced by a proceduralist who has had the imprudent idea of venturing into legal theory. That would be, at the very least, a significant contribution to my own morale. Thank you very much.